Outside the gates of the criminal court in Avignon, supporters chanted the words "shame on justice" as sentences were handed out in the Pelicot trial. The atmosphere was tense as a lawyer for one of the condemned men in the mass rape trial taunted the crowd and called the activists knitters and hysterical.
My client is free. My client is free.
He boasted that his client was one of the 6 men walking out freely, having only been held in provisional detention. The scene added salt to the wound for many feminist activists who said they felt humiliated by the sentences.
What bothers me is the notion of different penalties. While they're all the same offence under the penal code, that's rape. And for rape, our penal code says 15 years. How is it that certain men who we recognise have committed rape can walk free after 3 years?
For activists and observers, the Pelicot trial has highlighted the need to update French law. In the absence of consent as a legal criterion in France, defence lawyers were able to argue that the aggressors thought they were taking part in a consensual fantasy.
If we had in our French criminal law the obligation for the person who initiates sexual contact to ensure they have consent free of any coercion, the accused would not even have been able to plead a belief in consent since Mrs. Pelicot never said yes.
The country's criminal code currently defines rape as a sexual act committed by violence, coercion, threat or surprise, but does not mention whether or not consent is necessary. France was one of a dozen countries that opposed the EU's recent effort to establish a shared definition of rape based on the notion of affirmative consent, namely the idea that only yes means yes.
Let's move to the other world.